Before we get started, I'd like to just ask everyone when they're not speaking if they can mute their microphones. Sometimes the background noise can be distracting. So the first item on our agenda is a continued hearing for 35 Mountain Road. This has been something that's been continued for a while. Town council has given us an opinion on the easements, and we are going to discuss that tonight, but town council had a conflict, so she won't be able to get on till a little bit later in the meeting. So we will be talking about it, but we're going to take some of the other items on the agenda first. So if I could get a motion from the board to take, we'll start with 3 Forbes Ave, to take 3 Forbes Ave out of order.
Motion to take matters out of order, specifically Forbes Ave.
Second.
Okay, roll call. Jim?
Aye.
Charles?
Aye.
Mark?
Aye.
John?
Aye.
And I vote aye. Okay, so 3 Forbes Ave is a new hearing. Can I get a board member to read that into the record for us, please?
I can do it. The petition of Sunil Prajapati for property located at 3 Forbes Ave, Burlington, Mass, as shown on Burlington Assessor's Records, as shown on map number 5, parcel number 23-2335-0. The applicant is seeking a variance to convert the existing property of a single-family dwelling with an in-law area to a two-family structure. Reason for the denial is per the Town of Burlington zoning bylaw 4.2.1.1.a. Said proposed use is permitted. A condition to permit said use is needed for a 20% buffer with the minimum of 25 feet. Article 8, Section 8.5.5.5 between two residential zoned properties, 3 Forbes Ave and 5 Forbes Ave. Existing conditions show the existing structure being 13.1 feet, the rear corner of the addition being 22.5, and 2 sheds setting within the required buffer.
Thank you, Mark. Is the applicant online for 3 Forbes Ave?
Yes.
Yes, we are here.
Okay, if you could please introduce yourself and give us an overview of the proposal.
My name is Bharti Dalwadi. Good evening, one and all. Namaskar, respected chairman and board members. Thank you for giving us the opportunity to present our case. Here, my family members with us on call and with me. We have constructed a home for 4 generations to live together under one roof. Some of you have experienced multiple generations living together and aware of challenges. I am sorry, I cannot explain throughout in English. Bear with me. We are requesting a door between the main unit and low unit for safety, security of the occupants and efficiency of the home. It's 110 feet continuous living space. In-law units require 48-inch open space. We were here few weeks back for an accessory apartment. We were told that we should apply for 2 family as it's our by right. 2 family units need variance for the buffer zone. We need a barrier between units for aging 80+ years old parents. Privacy as their schedules is different than the rest of the family. Parents maintain a high temperature and high volume, which is expensive and uncomfortable for the rest of the family. Barriers isolate transmission of many diseases, including COVID, cold, flu. It also gives privacy to parents, healthcare providers, and home aides. Door adds fire safety and isolate HVAC zones. Usage of house would not change by these variants. It would remain residential. It would not convert into commercial property. It would not increase traffic. There is enough parking space with 2 driveways. And regarding shades, there were 2 shades. We have dismantled one and retained second. Shades height is lower than solid fence due to elevation difference. Our neighbors have no objection for the shades. Thank you.
Thank you. Let's go around the board. If there's any questions or comments, we'll start with Jim.
I'm just, can you clarify, so why, so it's basically just on paper that you want to convert it from an in-law to a 2-family dwelling? Am I understanding this correctly?
Yes, that is correct.
So there's no, sorry, go ahead.
We want to retain a barrier between, it's a 110-foot continuous living space. And we would like to retain some kind of barrier, like a door between 2 units. And our options are like, if it's in-laws apartment, we have to maintain 48-inch open space. So our options are convert into accessory apartment or family. And we are requesting for 2-family, and that was denied due to the buffer zone requirement. So we are here for the variance. So we are converting in-laws into a 2-family.
Okay,
That is our request.
so nothing's changing structurally or with any of the utilities? It's just,
Yes, we are not adding any new structure unless some utilities, nothing, like we have 2 kitchen already in place. So we are not planning to modify it. Our usage will remain the same. Our need is to retain a door. So we are not changing. We are not doing any net new construction. We are done with all the changes.
Mhm.
And the original unit was constructed in 1962. We added the addition towards 1/4. The new addition was.
All right, thank you.
Okay, Jim, you're all set? Okay, Charles?
I don't have any questions at the moment. We can go to another board member.
Okay, Mark?
Yeah, I'm going to defer to the rest of the board and reserve my position.
Okay, John?
Yeah, I'm good for now.
All right, Joe?
I don't have any questions myself.
Okay, Adam?
No questions at this time.
Okay, just as a clarification on the comment about not having to change anything. So the in-law apartment that they have right now, it's open. Both units are open together. There's no separation between them. That's what the bylaw says has to be. So by switching to the 2-family, they would be able to put that barrier up. They would then still need to meet all the building codes if they were to put that barrier up. So whatever the other building codes would need to be met, the building department would hold them to that. So what they're looking for is under the town center overlay, if they do a 2-family, it requires a buffer because the property next door is outside of the overlay. So the buffer is 20% of the lot, which their plan shows to be about a little over 40 feet, which cuts about halfway through their lot. So it's pretty hard to not be in that buffer zone. So the house is existing, so we'll just leave it at that for now. We'll open this up to the public and see if anyone has any comments on this. Please, it's kind of hard with the online, but if you could just one at a time, everyone will get a chance to speak. Okay, I am not hearing any comments from the public. Do we have anything else from the board?
Nothing.
To close the public hearing? Make a motion to close the public hearing?
Second.
Okay, motion is made and seconded to close the public hearing. Roll call. Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. All right, just, I mean, we'll take discussion, anything else anyone wants to say, but just another point is that the applicant will still need to go to the planning board for this. This is just a variance from one of those requirements that they would need before they take that step. So I don't know if anyone else has any thoughts on this or motions.
Make a motion to approve 3 Forbes Ave for a buffer variance of 13.1 feet.
So yeah, you're reducing it down to 13.1.
Yep, so, yeah, this is, so I'll make a motion to approve 3 Forbes Ave to, for a variance of 20% buffer, down to 13.1 feet.
Second.
Motion is made and seconded. Roll call. Jim, sorry, just before we do that, I think we should reference this plan.
Oh, sorry, yeah, that's my fault.
You have that plan reference?
Yeah, I got it. It's plan dated 5/24/21 as submitted.
Okay. Do we have a second?
Second.
Okay, motion is made and seconded. Roll call. Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. All right, you are all set. There are other steps I believe you'll need to take, but you're all set with us. You'll have to talk to the planning department and the building department.
Thank you so much.
Thank you very much. We
Thank
really
you.
appreciate
Thank
it.
you so much.
Thank you. Okay, the next item.
Pandemic with dance lessons. That would be super helpful, and being able to have the cars see us from the road. We're a little bit set back away from the road, so just a little bit of a bigger signage would be super helpful to get new students and keep our dance business going.
Okay, thank you. We'll go around the board and see if there's any questions or comments. We'll start with Adam.
No questions.
All right, Joe?
I don't have any questions.
Okay, John?
Yeah, no questions. I'm okay with this one.
All right, Mark?
Let me ask the applicant, is there any reason why you can't reduce the size somewhat? I mean, it does seem like it's over twice the size of the bylaw. I know that you have a brand there, but it seems that you should be able to reduce it somewhat. That's my comment, a question.
Sure. So, based on my research of the other dance studios that are in the area, there is another one in Burlington that has a comparable sign. So, just trying to stand out with the other people that are in our same industry in Burlington. That was kind of the sign, the size decision based on that.
And it is on the second floor, right?
So it's a little tricky. We're not really. We're on the ground floor. Behind the building is Kitty Academy Daycare, and that's more like below ground level. So technically, we're really on the first floor that you can see from the street level. I don't know if that makes sense.
No, it does. I'm going to wait to hear from the other members.
Thank you. Charles?
I don't really have any questions.
Okay, Jim?
No, I'm all set. Thank you.
Okay, I just have one question on just how is the sign illuminated? I don't really see it in the details here.
Sure. So I talked to Dave DeMeo over at Sign Effects and Bill Ricka. He's installing the sign for us. And I asked him about the lumens because I spoke with Joanne today, and she said that there's a limit, the lumens. So he assured me that the lumens would be under 50. I believe that Joanne said that the limit for the town is 90. I might be wrong with that, but that was the information that I was given from the sign, the gentleman that's installing our sign. So, and if we need to, we could do a dimmable power supply if we needed to as well, just to ensure that that was not blowing everybody off the street with our bright sign.
Okay, no, I think that's fine. So I guess my only other comment on this is that this property, I believe, is in the IG based on what the regulations that are written, and if it were in the BG district, then this sign would be allowed. So that's really my only comment on this. So I will open this up to the public. If there is anyone in the public that would like to speak on this matter, please state your name, and we'll try to take it one at a time. Okay, hearing no comments from the public, does the board have anything else before we close the public hearing?
I'll make a motion to close the public hearing.
Second.
Motion is made and seconded to close the public hearing. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John?
Aye.
And I vote aye. 5-0. Okay, any other comments or questions from the board?
I'll make a motion to approve 209 Middlesex Turnpike, Arthur Murray Dance Center, for one wall sign. As shown on plans dated 2/9/21, submitted with the application. With the condition for lumens not to exceed 90 lumens per square foot, and no other sign, even if by right.
Second the motion.
Second.
Okay, motion is made and seconded. Roll call. Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John.
Aye.
I vote aye. Okay. So the next thing on our agenda, which we need to vote to take out of order, which we didn't on the last one. Joellen, do you think we need to go back and take a vote to take that out of order, even though we already did it?
No, we can just say all of them were included.
Okay. All right. Okay, so the next item on our agenda is a new hearing for 94 Locust Street for a variance. Can one of the board members read that into the record for me, please?
Yes, I can do that, Mr. Chairman. 94 Locust. Petition of Nugent for property located at 94 Locust Road, Burlington, Mass, as shown on the Burlington Assessors Records at book page 69021-205, map and parcel reference 24-58-1. The applicant is seeking a variance to construct a 24-foot by 27-foot two-story addition, parenthetically two-car garage with bedrooms above to the right side of the existing dwelling, with a proposed setback of 18 feet off the right corner of the addition of the front property line. Denial due to Burlington zoning bylaw, Article 5, Section 5.2.0, density regulation schedule. No building or structure shall be constructed, nor shall any existing building or structure be enlarged or altered except in conformance with the DRS as to lot coverage, lot area, land area per dwelling unit, lot width, front, side, and rear setbacks, maximum height of structure except as may otherwise be provided elsewhere. Setback of the addition will be less than 25 feet, minimum required setback.
Thank you. Is the applicant online for this matter?
That is me. I am Yet Nguyen.
Okay, could you please give us an overview of the application?
Yes. So we were looking to build an addition, two-car garage with possibly 1 or 2 bedrooms above. We are having 4 children. I am expecting another one in September, so we need extra space. And in order to build that, because our house is not parallel to the street, one of the corners would go beyond that 25-foot setback. So more like an 18-foot setback.
Okay, thank you. We'll hear from the board. We'll start with Jim.
Thank you. So did you guys consider, there's no rendering, did you consider moving the addition back so that you were, so basically move it back 7 feet so that you did comply?
We did consider that, but we have an addition already there, and there are windows on that side. And so it would, I think it would be more difficult to build beyond that, our normal structure, our original structure.
Okay. So it's within probably 7 feet of the end of the building, a window?
Yes, if we were to build beyond that,
Yeah.
then it would cover up some of the addition that we have now, the family room or something.
And did you say there's a 2-car garage? I'm sorry.
No, oh, we would like a 2-car garage
Yeah,
addition.
okay. All right, those are the only questions I had.
Okay, Charles?
No, I have similar comment where, you can definitely move it back, understand there's windows there. You can probably do without a variance. Would be nice to see floor plans if you had some type of plan already done to see. Especially with these ones, I like to put that in as part of that application as well. But I mean, that's just my comment right now. I feel like this could probably be done without a variance if it needed to be.
Okay, thank you. Mark?
No questions.
All right, John?
Yeah, no, I'm good.
All right, Joe?
No questions.
Adam?
No questions.
Okay, I have similar comments. I'd like to see some kind of architectural drawing to show us why you can't push the addition back. Because looking at the plot plan that was submitted, it looks like you have plenty of room to be able to do that. So it's kind of hard to want to look to grant a variance for that. My other question is, and it might really be more for the building department. It's showing that your existing setbacks are less than 15 feet on the side for your side yard. Did the building department comment on that at all to you?
Which on the other side?
Yeah, where it's on your plan, it's showing 14.4 and 14.7.
Oh, that I have no clue. That was, no, they didn't comment on that. But that was the original. That's the original house.
Yeah, no, I understand it's existing. It's just usually when someone comes in front of us and they're looking to do an addition and there's an existing nonconformity, usually the building department will look to add that to the variance just to make everything compliant. I mean, it's kind of paperwork, just cleaning it up, but I'll have to talk to them about that and see why they didn't comment on that. Okay, so we'll open this up to the public. Does anyone in the public like to comment on this application? Please state your name and we'll try to take everyone one at a time. Okay, I am not hearing anyone from the public, but I think we can go back to the board and see if there's consensus on wanting some additional information. To the applicant, do you have architectural drawings that you could submit?
I have an architect. He basically just did the exterior, the borders, the perimeter, but not the actual interior yet. Is that what you were looking for? Interior as well.
I'll put that to the board. I mean, I guess if we saw the exterior and saw where the windows were, and we're just trying to for a variance, you have to show a hardship. So to look at this plan to see that there's a lot of land that you could push this back and potentially not get a variance, we need to look for a reason to grant it. So potentially, the layout of the house, or the layout of your windows potentially could be something that we could look at. So the more information that you can provide to us, I don't know if any of the other board members have additional thoughts on information they'd like to see.
Yeah, I agree with you, Mr. Chairman. I think that would be helpful to the board.
I will contact him and ask if he can do that. I don't have the drawings right in front of me, but I don't think he included all the windows yet.
Yeah, if you could get that to us before our next meeting, and we can have a chance to review it, and then we can discuss it at the next meeting, and then we can make a decision. And I'll talk to the building department in the meantime and ask them about the side yard setback on the other side.
Okay.
Okay. So I will take a motion to continue from the board.
Make a motion to continue 94 Locust Street to June 15th.
Yes.
Second.
Okay, motion is made and seconded to continue. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. All right, we will see you at our next meeting on June 15th.
Okay, sounds good. Thank you.
Okay, I just got a message from town council, so I'm going to find out how long she's going to be. If you can just bear with me for a minute. Okay, in the meantime, why don't we have a couple of small things. We have our minutes from May 18th. Has everyone had a chance to review the minutes?
Yes.
Okay, we'll take a motion.
Make a motion to approve the minutes.
Second.
Motion is made and seconded to approve the minutes of May 18th. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. Okay, this isn't on our agenda, but it's just an appointment from the board to the housing partnership. Charles has held that role for a while now, and he has some conflicts with the scheduling for that. I believe the housing partnership meets once a month. I don't know exactly when that is, but I'd be they're looking for a volunteer, for someone that would like to participate in those meetings. If anyone is interested.
I'll do it if you need somebody.
Okay, yeah, that would be great. I mean, we can relook at it. It doesn't have to be the same person. We could, every year we could take a new look at it, or if your schedule doesn't work out. So
I can do it.
Yeah, okay. I don't believe we need to take a vote on that. It's just, looking for a volunteer. So I will inform the selectmen on that.
Okay.
And I'll make sure they reach out to you about when the meetings are. Sorry, I'm just checking town council. All right. Town council says they're going to be a few minutes, but before we get into that, I guess I have one more thing to just discuss with the board, and then we'll decide what we're going to do. So just looking forward at our schedule and information that I've gotten from the town about live meetings versus public meeting versus virtual meetings. So as after June 15th, they've indicated to me I need to confirm that it'll be our decision, at least for the time being, whether we want to do virtual meetings or live meetings. So I wanted to put it out to the board and see what they thought. And on kind of on the same note with that, because it would be the next meeting after the 15th, is a meeting on July 6th, which you know is a pretty popular vacation week. I will be on vacation, but I could join the meeting virtually. So I just wanted to see what the board thought, if we wanted to stay virtual till after that, if other people weren't going to be around, or if we want to go live on the 6th, then I could potentially call in if someone else ran the meeting. So thoughts from the board.
I'm fine with going online until after the 6th, if that's fine. I mean, more meeting should be.
Fine with me, as long as we go to in person after that.
I'm good with that.
I'm agree.
Okay.
After July, let's go live.
Okay, all right, we'll plan on that. I will let everyone know. I'll confirm once I've confirmed that with the town clerk.
It looks like it would be July 20th.
Okay. Not that these virtual meetings aren't fun, but so, all right. So just an update from town council. Her other matter that she's stuck on is running long. They're supposed to be on within the next 5 minutes, and then she thinks it'll take about 15 minutes. So she's, you know, asking whether we would want to take a break, and then we could get to this tonight. I'm not sure what the board thinks about that. I'd like to try to get somewhere on this tonight.
Yeah, I mean, I'd like to see some movement on it.
So I think her opinion kind of speaks for itself. I don't know. I mean, I don't.
No, just but
hear from the rest of the board, but I think it's pretty clear myself.
Yeah, but I want her to be here in case there's questions that are raised either from board or from the public. I don't want to get too much into the matter itself because we haven't really opened that agenda item, but just, I mean, we can open it, we can start discussing, but I think she's going to be, if she jumps in and we're halfway through the discussion, we're going to end up talking about it all over again anyways. So if everyone's all right with it, I'd like to see if we could wait, but she's asking me if we can take a break until 8:40 to be able to get her on.
I mean, is the applicant okay with that? That they in agreement with that?
Is the applicant online?
He is, or his representative is. The board has been very agreeable to our requests over the period of time for various reasons, so I'm willing to do whatever the board's wishes are on this.
Okay, I mean, Joellen, is there any reason that we can't take a break and say we're coming back at 8:40? I mean, this is new for us. We've never done this before.
I don't, as long as everybody's okay with that.
Yeah, I think we can vote to take a recess.
Yeah, okay. If the board's amenable to that, we'll take a motion.
Is it going to be to a time specific, Mr. Chairman, or?
Yeah, let's, she said 8:40, so let's say 8:40.
Okay.
I'll make a motion to take a recess until 8:40 p.m.
Second.
Okay, motion is made and seconded to take a recess till 8:40. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye. Okay, we're sorry for the delay, but I think it's important the town council be here, so we will be taking a recess till 8:40 and we will be back online. Joellen, you'll just be keeping the meeting open, right?
Yes.
Okay. All right, then we will see everyone in about a half an hour. hearings. Can I take a motion from the board to take the items for 35 Mountain Road and Richardson Road together?
I'll make a motion to take Richardson Road and 35 Mountain Road together.
Okay,
Second,
I have a second. Okay, roll call. Jim,
Aye.
Charles,
Aye.
Mark,
aye.
John, and I vote aye, 5-0. Okay, so this is a continued hearing for 35 Mountain Road and a continued hearing for Richardson Road. I would like to start with Lisa Mead, Town Council, and have her give us a summary of her opinion letter that has been submitted. Lisa, if you could give us an overview.
Sure. Thank you, Chair and members of the board. And I greatly appreciate your indulgence from that meeting that I just was hungover on. Well, maybe I was hungover. I don't know. Stayed over on. So I provided to the board a memo last week regarding the question of access and rights of access over what I'm going to call, and I call in my memo, the extension easement. So at the end of Richardson Road, there's a section about 90 feet before you get into, let's call it Windview Heights condominium property. And that section, that 90 feet, I'm going to call the extension easement. That's what I refer to in my memo. As this board knows, the board requested requested the applicant's attorney to provide an opinion to the board relative to the rights of access over that way or over the extension easement into Windview and then onto, and then the right of access over the Windview property onto the property that is a source of the application in front of the board. I reviewed the applicant's attorney's memorandum. Also, the owners of Windview engaged counsel, and they too provided a memorandum to the board regarding their legal point of view. So I reviewed that as well. I pulled and provided to this board all of the related title documents that are at issue, which was part of the package that I provided to the board. And I'm going to go to the end of my memo, and then I'm going to go through the facts for a minute. Typically, a planning board or a zoning board is not to decide issues of title. If there's a discrepancy in title or a property dispute, a private property dispute, typically a zoning board or planning board would not be asked to or even allowed to engage in the determination of who owns those private property interests or who has a right to those private property interests. However, the exception to that rule is that where that interest goes to the heart of the matter, that is before the board, that is, they couldn't decide the matter but for deciding the dispute as to the property interest, then it is within the purview of the board to, in their determination, decide or make a determination so they can move forward or not related to that property interest. Obviously, the board's determination wouldn't necessarily be legally binding. That could potentially only be determined by a court of law. But for the purposes of the hearing before it, the board may want to make or have to make that determination as it moves forward. So first, the board will need to decide if this determination, that is access over the easement extension, and then after that, Windview 1, goes to the heart of the matter of the application before it. That'll be the first determination. And depending on whether you decide it goes to the heart of the matter or not, would be just whether or not you decide the substance of those facts. So I reviewed for the board in my memo the facts related to that extension easement. First, let me say it would be my opinion that in fact the current applicants or the owners of the land, the Hussey Boutreau land of 35 Mountain View Road, I believe, in my opinion, have a right to use the right-of-way or the driveway that runs through Windview 1 condominium. You all have been provided with a conditional access agreement, and it would be my opinion that certainly the applicant and the owners of 35 Mountain View Road have the right to go through that property. However, the issue related to the extension easement is not so clear. So Richardson Road was developed by Murray Hill Incorporated, and that road included 6 lots, and I provided you that subdivision plan. The road is now known as Richardson Road. As I said before, did not extend all the way to the end of all of those lots. In fact, it stopped right at the beginning of what is called lots 3 and 4 in those plans. It was about 95 feet short of what became the Windview 1 condominium property. In 1983, Murray Hill deeded lots 1 to 6 out to Windview Development Realty Trust, but retained the fee interest in Richardson Road and also retained that 40-foot right-of-way that runs between lots 3 and 4, or actually that are parts of lots 3 and 4, as an easement and a right-of-way, not a road. And in that retained easement, it says that it is a permanent 40-foot right-of-way and easement over lots 3 and 4, as shown on the plan, for the benefit of all land contiguous to the lots 1 through 6 inclusive. In that instance, that would have been lot 8, which was contiguous, and that is the land upon which Windview Heights condominium was constructed. And in 2001, indeed, Murray Hill conveyed lot 8 to Housing for America Realty Trust. With that deed, Murray Hill conveyed to Housing for America Realty Trust the right-of-way being shown as 40-foot wide line between lots 3 and 4 in the plan. That is what I refer to as the extension easement. So that was conveyed to Housing for America. And then after that, you should note that originally Murray Hill reserved for itself the right-of-way and easement over lots 3 and 4, as opposed to a fee interest in Richardson Road. So it was an easement that they retained, not a fee interest. By Murray Hill deeded to, by the Murray Hill deed, Housing for America gained the right to pass and repass over the extension easement. So when Housing for America developed Windview 1 condominium, they retained the right and gained the right to pass and repass over the extension easement. And again, I would point out to you that the original reservation of easement was for the benefit of the land contiguous to lots 1 to 6. In that instance, it would have been lot 8, which was where Windview 1 was developed. Then the conditional access easement, Housing for America granted to Hussey and Boutreau the right to pass and repass over the property owned by Windview 1 condominium land. That's clear in that conditional access easement. The rights being appurtenant to the land of the grantor, namely Windview 1 condominium, that deed does not refer to nor incorporate by reference, and quite honestly, under the law as I've set out, it couldn't, a grant of easement over the extension easement. And further, the Hussey and Boutreau land, or that land of 35 Mountain View Road, is not contiguous with lots 1 to 6 on Richardson Road. So those are the facts. You all have that. And so the question is the determination of the rights to this extension easement, does it go to the heart of the matter that the board is trying to decide? That's the first question you need to decide. And if you decide that it does go to the heart of the matter, then you need to decide, based upon the facts and the law that I have given you, whether or not the applicants have a right to use that extension easement. If you decide that it doesn't go to the heart of the matter, you don't have to decide anything and you can continue on with the application.
Okay, thank you. We'll go around the board. This is for the board and for everyone else. I'd like to keep this discussion on the easements and on the opinions on the easements. I don't see any point right now into getting into any other details on these applications until we get this matter settled. So let's go around the board. Jim, do you have any questions or comments on this?
I do not at this time, no.
Okay, Charles.
No, I mean, I think that the decision is pretty clear. Just a matter of for me anyway, whether it's the heart of the matter or not, which I guess I need a little bit more, if I can get a little bit more in like layman's terms of what I'm thinking of, what I'm supposed to be thinking of with that, I guess.
Would you like me to address that, Mr. Chair?
Yes, please.
So the question is access to the property necessary in order to make a determination on the application? The access to the property is presented, right? So if there's no access to the property, can you make a determination?
Okay. I think I get it now. I don't have any other questions at the moment.
Okay, Mark.
So I have a question for town council because as I read your memorandum, there was a case that you cited that said the board does not have authority to determine the existence of easements or settle property disputes. Isn't that what we're called upon to do here?
Well, that's why I said, Mr. Burke, that's why I started my comments out by saying that's the general rule. If you go on to read the third to the last paragraph of my opinion, I say exceptions to the above rule do infrequently exist. And what the courts have said, you have to rightly consider matters of title of ownership where it goes to the very heart of the proposed development. And so the general rule is, as I said before, is the board doesn't get to decide property disputes unless, and here's the exception to the rule, unless the resolution of that property dispute goes to the heart of the matter that's before the board.
So the case that you cited there for that proposition, it actually went back to the board. In other words, it was remanded to the board to make a determination. In other words, it's really fraught with all kinds of factual questions. I mean, and that's what seems to be necessary to flesh out here, right? Whether it goes to the heart of the proposed development. So can you give us a sense for what factors would be considered for the purpose of determining whether it goes to the heart of the proposed development?
So, yes. So you've got an application before you that has access, shown access, one way in and one way out. And the board typically looks at, traffic, public safety, whether or not emergency personnel can get to something. Can you run utilities to the project? Because if the project doesn't have access, if emergency personnel can't get there, if you can't run utilities to the project, is it a project that you would approve? And so those kinds of factors.
And you would also be exploring some other means of access? Is that?
Well, you don't. So right now you have an application before you that has one means of access. That's not to say that there aren't other ways to get to this property. That's just not before the board right now. You're not designing the project. The project is designed before the board has one means of access. It's true that the owners of the property of 35 Mountain View Road do own other property that's adjacent to another public way. but that proposal is not before the board at this time.
Okay, I'll wait to hear from other members.
Okay, thank you, Mark. John?
Nothing new from me. I want to thank Charles and Mark. Those are good questions. Thank you.
Okay, Joe?
I don't have any questions.
All right, Adam?
No new questions at the moment.
Okay, I just have, one question just kind of for the whole board. Well, it's for town council, but if we are to determine that access over these easements does go to the heart of the proposed development, then we need to make a decision whether we are forced to then make a decision to say whether we think they have access or not, and to either deny or not deny based on that, correct?
Right. I think that you, I don't think it's quite that black and white. I think that you would, if you decide that it goes to the heart of the matter and you decide that, but for this access, you couldn't hear the application, then I would give the applicant the opportunity to withdraw the application or have it denied, if that was the sense of the board, and they could appeal that, or they could withdraw it and redesign it and come back, if that's a possibility.
Okay, thank you. Okay, I'm gonna open this to the applicant for comments from the applicant, and then I will open this to the public for comments. Again, I'd like to just try to keep the topic on. Oh, I'm sorry. Before I do that, we got a letter that we were asked to read into the record. I believe it came from Sherry Ellis. It is a letter I'm going to read into the record from the Commonwealth of Massachusetts, the Department of Housing and Community Development, dated February 19th, 2020, addressed to Mr. Joseph Morandi, Chair, Board of Selectmen, 29 Center Street, Burlington, Mass. 01803. The reason for the letter: Chapter 40B Comprehensive Permit, project name Windview Heights 2, location Burlington, number of units 24, subsidized agency Department of Housing and Community Development, applicant Windview Heights 2 LLC. Dear Mr. Morandi, this will serve to notify you pursuant to 760 CMR 56.043D that the above named applicant has applied to the above named subsidizing agency under the local initiative program for preliminary approval of the above referenced project. The project is a 55+ home ownership development with a total of 24 units, 6 of which are low income under 40B. Enclosed, please find a copy of the application for your review. The review period for comments ends 30 days from the date of this letter. Any comments will be considered prior to issuing a determination of project eligibility. Please address comments to Catherine Racer, Associate Director, Division of Housing Development, Department of Housing and Community Development, 100 Cambridge Street, Suite 300, Boston, Massachusetts, 02114. If you have any questions regarding this letter, please feel free to contact me at 617-573-1322. Sincerely, Elena Murphy, Deputy Associate Director, carbon copy, Gary J. Litchfield, Windview Heights 2 LLC. Okay. Again, we were requested to read that into the record. So if the applicant can comment on the opinion on the easements, and then we'll go on to the public comment for, again, try to stay on topic with the easements.
Thank you, Mr. Chairman. Thomas Murphy, present for the applicant. I believe the applicant is also on the call. A couple of things in response or rebuttal, if you will. The main overview of the point is there's clearly a disagreement or a difference of opinion in any event as to whether or not there's proper access or sufficient access for this project to go forward. I've obviously read Attorney Mead's letter, and I heard her presentation. I would point out that the actual easement that was reserved over lots 3 and lots 4, and not the one that Mr. Murray's deed referred to, which reserved in Murray Hills certain rights. But when the Windview Development Realty Trust, which actually constructed the houses on that part of Richardson Road, when they sold off lots 3 and lot 4, the language in their reservation of easement over that right of way was for a roadway similar to the language in the Murray Hills deed, and it also contained the contiguous language that was in the Murray Hills easement, but it also had a additional language added to it, and it specifically referred to land hereafter acquired. And I think that's important, Mr. Chairman, and hasn't really been discussed, and is certainly a matter of interpretation. But the principle back at that time of Windview Development Realty is the same principle as was before the board on this on the Windview 2 project. And he was also the one that developed the Windview 1 condominium project. So clearly he's been developing land up in that area of town for a while. He will tell you that that language, the additional language that was added into his deeds about hereafter acquired property, was because he was aware that not only was there adjacent land, as council referred to in Lot 8, but there was also another large substantial piece of land beyond that he had in his mind that he was going to speak with the owners and try to work something out with them, which ultimately he obviously did. So that's why that language appeared there. I would submit that if that wasn't the case, that language wouldn't have been, there would be no purpose or reason of putting that language into those deeds, because you already would have had sufficient rights to get into Lot 8. So I don't think the board can ignore that language. And like I said, there might be a difference of opinion as to the effect legally of that language or the rights conferred by that language, but it's clearly there, and it's there for a reason. And like I said, Mr. Litchfield, who was the principal of both of the entities that were being discussed here, would tell you that the reason was that was his intent, and that's why that language was inserted to begin with. With respect to the ability or the decision the board has before them as to whether to take on this determination of whether the access is there or not there, I would submit that the case law is cited in Attorney Mead's letter, and I think as Mr. Burke referred to, clearly, in my opinion, stated that it's a very rare occasion that the board, not just this board, but any permitting board, would get into that type of a decision. And the language has to go to the heart of the matter. I think, in my opinion, the definition of heart of the matter has been given as a rather broad definition in what in reality is a test that the court has said is very rarely applied. So, I mean, technically any development project before any permitting board anywhere, access and ownership are obviously go to the heart of the matter. Boards don't get into those types of things anymore, and the case law backs that up, because frankly, it's not their position. And with all due respect to the board, I would submit that the board doesn't have the background and the knowledge that's required to research and interpret and ultimately come to a conclusion as to the effect of the language of the various easements and deeds and whatnot that we're all looking at here. I would suggest that, in my opinion, what goes to the heart of the matter of this particular project that's before the board. It's not access. This is an application for a comprehensive permit per the local initiative program. The town of Burlington, through its Board of Selectmen Housing Partnership, has determined that there's a public benefit to this project going in. It's an age-restricted project. 25% of the units are affordable. And the Board of Selectmen and the Housing Partnership both issued the opinion in the vote unanimously, with the selectmen anyway, that it's to the town's benefit for this project to go in. I would suggest that, in fact, is what goes to the heart of this matter. This board is determining whether this comprehensive permit should be allowed or not, should look to the heart of the matter. Is there actually public benefit here? Is this something that's good for the town of Burlington? Does it provide housing needs and that
Did everyone else lose Tom, or was it just me?
Yeah,
No, he's gone.
All right, let's give him a minute to see if he gets back.
on that portion of it, as far as their decision goes, let the access questions be answered by courts if they become necessary. So thank you, Mr. Chairman, for giving me the opportunity to be heard.
Tom, sorry, we lost you for the last minute or so there.
Oh, that was the best part, Michael. I'm not sure I dropped off. I did see that some circles going around on my computer, so I figured I was in trouble. But the gist of what I tried to wrap up with, Mr. Chairman, is that the heart, and I don't know if you heard this part of it, but I would suggest that the heart of the matter of this particular application is whether or not this project provides a benefit to the town of Burlington, as the town of Selectmen and the Burlington Housing Partnership have all voted. It provides age-restricted housing. 25% of them are affordable, and that meets a need that the town of Burlington housing stock is important to the town of Burlington, and that's what the heart of this matter is. I would suggest whether or not there's access, or the extent of the access, ultimately, if it goes that far, a judge someplace will make that decision. It's not the place of this board to be making that decision. You just don't, frankly, have the expertise, the background, and the ability to do that. You should focus, in my opinion, on whether this under Chapter 40B meets the criteria, the rules and regulations under that statute, provides a benefit to the town of Burlington, and let the access questions be answered by a court of law if and when it gets to that point. Thank you.
Okay, thank you. Okay, I'm going to open this up to the public. I'd like to see if we could have everyone just go. No, we can still hear you, Tom.
May I address the board?
Yep, I'd like to just take everyone one at a time, and if everyone else can just be muted, I will give everyone a chance to comment. Again, if we can keep the topic on the easements and the opinions on the easements, I don't think we're getting into the other matters at this point.
Hi, my name is Diane Downs. I live at 12 Richardson Road. I'm part of the extension easement. According to my deed, subject to the reservation of perpetual easement for road purposes, and also the reservation of the rights and easements to construct said roadway and install all utilities in and over the same as set forth in deed from Patricia M. Litchfield trustee of Windview Development Realty Trust, to Anthony M. Coco and Kathleen T. Smith Coco, dated November 17th, 1983, and recorded with Middlesex South District Registry of Deeds and Book 15320, page 488. In this, I don't see how the Litchfields were able to appoint the Hussies and Windview Heights 2 rights over to the use of our easement. And I believe that the number cited of 89 additional vehicles per day going over the easement, I don't know if that includes UPS trucks, FedEx, DHL, and Amazon trucks, which would greatly increase that to over 89 vehicles a day. And based on Lutheran High School Association v. Woodlands 3 Holdings of 2003, I would like to know what was the amount of traffic contemplated by the parties at the time of the grant of easement. I feel that 89 to 100 more cars a day would, under Green versus Templin 2010, decrease my property value, and increased noise and traffic would interfere with our peace and enjoyment of the land.
Okay,
Thank you for your time.
thank you.
Mr.
Is there
Chairman?
anyone else?
Yes. Hi, Mr. Chairman. Attorney Matt Gaines with the law firm of Marcus Orrico, Emmer and Brooks. We represent the Windview Heights condominium. As Attorney Mead indicated, and I think hopefully you saw, we did submit a letter on May 17th, which was in response to the letter from the applicant's attorney. With respect to the rights over the end of Richardson Road, we do touch on this a bit in our May 17th letter. Town Council's memo did a far better job than I did of explaining this issue and why exactly the applicant and the abutters there, the Hussey Boteros, do not have rights over the end of Richardson Road. So I'll sort of defer to their memo, Town Council's opinion on that. What I do want to touch on, though, briefly discuss, is the abutters easement over the condominium, which is the subject of that 2003 conditional easement. Town Council's memo did not really touch on that. In addition, Town Council did say she thinks that the Hussey Boteros, in her comments tonight, Town Council did say that she thinks the Hussey Boteros do have easements over the condo. I don't want to put words in Town Council's mouth, and obviously she can correct me if I'm doing that or if I'm saying something incorrectly here. But what I assumed Town Council meant to say was that in the event the conditions in that 2003 conditional easement are met in the form of the board approving the application before them, then they have easements over that. And obviously that's important because I don't think they've met the conditions in that 2003 easement that's the subject of the other application before us. Again, the 2003 easement from the condominium developer to the Husseys and Boteros states that the abutters' rights over the condominium are conditioned upon the grantees obtaining approval from the ZBA to amend the site plan and any applicable conditions or restrictions granted in the condominium's comprehensive permit. I reviewed the application that was filed, and I don't really understand how the site plan or how the permit is being amended. I've read it. I can't figure out what they're asking for. What's being amended? I don't need to tell you this, but normally when you amend a site plan or you amend a permit, it might be to add the number of units. Maybe the original permit had 12 units and now they want to amend it to increase it by 10 more units. Or maybe they want to change a condition. Instead of planting 12 arborvitaes, they only want to plant 8 arborvitaes. Again, things you already know in terms of amendments. Again, there's nothing which resembles a typical amendment in the application before you. And I think Attorney Murphy, talked a little bit about the developer's intent when he granted this easement back in 2003 or even before then with the Murray Hill language. And I think let's talk about that a little bit more, because I think if we really look at this, we know what the developer's intent was. The developer's intent was to buy this Hussey and Butero land and make it part of the existing condominium. We can tell that by the language in the 2003 conditional easement. More importantly, look at the condominium documents for Windview Heights, my client's condominium documents. They talk about that developer, the same developer here, having rights to add more units to the condominium. That language was right in the condo docs. Those rights have since expired, which is why he's not doing that, and instead has to do this different project. So again, we're not adding units here. So the whole purpose of the 2003 conditional easement is not being met. But more importantly, there's nothing in the application before you that resembles an amendment. What they're asking you to do, which I don't even understand how you can do this, is they're asking you to amend the site plan in the comprehensive permit to declare the easement is valid. Well, as town council just indicated, you can't declare a property interest. And Attorney Murphy said the same thing moments ago. So you can't declare that they have easement rights over that by amending a permit. All you can do by amending a permit is to change the number of units, to change conditions, things like that. Not what they're asking you to do here. So, again, I don't think we even need to get to that issue because I think the issue on Richardson Road sort of settles this, that they don't have any rights over that. But if somehow you find that they do, well, then you can't possibly find that they have rights over the condominium land because the application to amend the comprehensive permit simply makes no sense in its context. And thank you very much.
Okay, thank you. Is there anyone else in the public that would like to speak on this matter? I'm just going to give it a minute. I know there's a lot of people on this call.
Mr. Chairman, this is Shari Ellis. Can you hear me?
Yes.
I have a statement to make or just a comment, if it's acceptable.
Yep. Yes, go ahead.
Well, all right. Thank you. I appreciate you reading the letter into the record earlier. I do want to make a comment in reference to Attorney Murphy's statement, not really to the easements, but to the heart of the matter. So I don't know if we go off topic a little bit here, but the heart of the matter he stated was that is this a appropriate development and a benefit to the town voted by the Board of Selectmen and also the Housing Partnership. I'd like to make note that the Board of Selectmen, 5 members, voted in favor of this at a couple of public hearings where there really were no other comments made by any other boards or any other residents at that time. And if there are no meeting minutes from any of the Housing Partnership meeting that happened with regard to this vote. So I really just wanted to make that as part of the public record that there were very limited number of people that were involved in the initial comment period for this. So thank you for your time.
Okay, thank you. Is there anyone else in the public that would like to comment on this matter? All right, I'm going to leave the public hearing open for now. I'd like to ask town council if they have any comments on a couple of the points that were raised. Just if not, then I'll go to the board. Attorney Murphy had a comment about the or hereafter acquired and on the language in there, and which was added to, and I just to town council if you have any comments on that language and how that would affect anything.
I happen to respectfully disagree with Attorney Murphy on that. I think that there's not a clear grant of easement, and it would have to. You can't grant rights that you have to a third party that had no relationship to the original grant. I think the law is clear on that, and so I respectfully disagree with him on that. And the board can decide whether or not this is the heart of the matter. That's up to the board.
Mr. Chairman, you're
I-
muted.
I think you're muted.
Um, so just if there's any comments on Attorney Gaines's comments about the conditional easement and whether anything would need to change on that to make that
Sure.
valid.
Yeah, so I would agree that there are definitely, it's a conditional access agreement, so you would have to satisfy the conditions that are part of that access agreement in order to take advantage of it.
Okay. Okay, so I'm going to open it up to the board. If anyone has any questions or thoughts on this, related to the easements and the heart of the matter and a direction to move forward, or to a direction to move, anyways.
So, Mr. Chairman, I would only add that I do agree with the applicant's counsel, Attorney Murphy, that, this is kind of outside of our purview, that there are issues that sort of go beyond our ken, but I feel like there are a whole host of legal issues that need to be resolved. And I'm wondering, and I put this to town council, whether there could be a declaratory judgment on some of these issues.
Through you, Mr. Chair. Of course, but obviously that's beyond, that would be amongst the private parties.
I get that, but is that, I understand that, but I'm asking you, is that something that's a remedy here?
Sure.
Is that a remedy?
Right, because it would decide the property interests, right? It would resolve those questions for sure.
Right. So, I only throw that out there because I think it would assist the board to have, you indicated in your memo that this is really for the land court or the Superior Court to decide. So wouldn't we sort of be putting the cart before the horse to be fleshing all this out without proper guidance?
So you you didn't ask for the application to come before you before this issue was resolved, right? The issue came up once it came to you. And so now you have an application before you. So either the applicant can decide to withdraw and get the matter resolved, or decide to press ahead. And if the applicant decides to press ahead, the board needs to make a determination.
Yeah,
And they, right.
I get that.
Yeah. So that's the resolution.
Thank you.
Okay. Any other comments from the board? Feelings on? I mean, I guess, my thought on this, I actually agree with Attorney Murphy as well. I don't believe that this is something that should be determined at our level. I think this should be resolved at the court level. But I don't necessarily know that I agree with that. That means we should move forward with this application and then wait to see if it's appealed. And whether it goes to the heart of the matter, as much as I can understand it, one of the major criteria that we would need to look at from our mandate to look at a 40B project is, the traffic and the safety, and which I would include access in those. So I would say that it does for our mandate of this part of the process. If they can't access the site, is it safe? And traffic might not be the right word. The traffic flow, would it work at all if they didn't have access? Obviously, it wouldn't. So, you know, again, leaning in direction whether we're going to make a determination here. We can get into that. I don't know what other board members think about this qualifying as going to the heart of the proposed development. That seems to be what we need to determine first. So, and then, you know, we decide after that whether which way we feel like we would vote on it to move forward or not move forward. I don't know if any of the other board members have comments on that aspect of it.
Yeah, Mr. Chairman, from my first perspective, it's really tough for me to you know, move forward, you know, in my mind without knowing if this easement is, you know, legal or not. You know, if we can't make that determination, I don't see how, in my opinion, we can go forward. But, I think if I had to make a decision tonight, I mean, I agree with Attorney Mead in that they don't have really a standing on that extended easement. That's how I would vote if I had to do it.
Okay, anyone else from the board?
Mr. Chair, could I just add one more thing from the applicant standpoint?
Yeah, go ahead.
Just briefly, without getting into the back and forth, I think we've done enough of that so far this evening, but my understanding was that this was going to be discussed this evening, then continued to the next meeting for the board to determine how to proceed. Knowing that, or that would be my understanding, I was going to submit a memo in rebuttal after tonight's hearing for the board to consider as you made that decision, presumably at the next meeting. So I don't know whether the board's intention is to take a vote on this evening or not, but I would just, I just wanted to state for the record that it was my understanding that tonight was an informational thing, discussion, and that the matter was going to be continued to the next meeting.
Yes, that was my intent as well. I'm just trying to get everything out on the table.
No, that's fine.
You know, to get the opinions of the board. No, just get the opinions of the board members out there so that you have an idea, because there is an option, as you as the applicant, whether, you know, after you've heard what the board has to say, and again, to say, you know, you might have more points for rebuttal, but you're procedurally, the applicant may have a decision to make on whether they want to withdraw or not withdraw. So I just want to get all the board members' opinions out there. But no, I would think we would continue. Everyone can think it over for the next 2 weeks. We can get whatever new information may come in, but then there probably would be a decision one way or the other at the next meeting.
Thank you.
Anyone else from the board? Any thoughts on this one? Weigh in so that everyone knows where we stand or where we're thinking we're going to stand on this.
I just to follow up on Attorney Murphy's comment, I would appreciate a rebuttal to. I know you've seen these two memos from Town Council, the condominium. You know, to rebut that, I think would be helpful to the board.
I'd be happy to. I actually didn't receive a copy of the memo from the condominium association's attorney, but I'm sure I can chase one of those down.
Yeah.
Yeah, we can get it to you. It should be online, but we can get you a copy either way.
I can send it to you, Tom, as well.
Thank you, Matt.
Okay, if there's no other comments from the board, we'll wait to hear any other comments that anyone else has that they want to submit. I mean, or speak at the next meeting on this matter. But I think it's clear that at least a few members are leaning into not being comfortable making this decision, and if we have to make the decision, then we'll have to decide on how we're going to move forward doing that. Again, I'll put it out to the board one last time. If there's any other comments before we continue this matter?
Mr. Chairman, I just want to just make a quick comment on the Housing Partnership Committee that I've been a part of for a long time. I did vote for this project as well as 2 others that night, I believe, to go forward with limited information. And you know, I felt my vote was a vote for senior housing in Burlington, not necessarily every project that comes in. I just wanted to get that on the record.
Okay, thank you. All right, if there's no other comments from the board, I will take a motion.
I'll make a motion to continue.
Second.
Okay, the motion is made and seconded to continue 35 Mountain Road and Richardson Road to our next meeting of June 15th. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. Okay, so I believe that we went through everything else on the agenda. Yeah, we did the minutes, right? Yep, okay. So unless anyone has any new comments or new business, I will take a motion to adjourn.
Make a motion to adjourn.
Motion is made and seconded to adjourn. Roll call, Jim,
Aye.
Charles,
Aye.
Mark,
Aye.
John,
Aye.
and I vote aye, 5-0. All right, we will see everyone on the 15th, and in July, we'll actually see everyone live.
Thank you.
All right, thank you.